My name is Shin Dai, and I'm Associate Professor at Peking University Law School. It is my great pleasure tonight to welcome all of you to this book talk organized by Princeton University Press and Columbia Global Center in Beijing jointly. So today we are very honored to have Professor Katharina Pistor as our speaker, and she will be sharing with us her wonderful book published in 2019, and the title is The Code of Capital, How the Law Creates Wealth and Inequality, like this. Yeah. So, Professor Katharina Pistor, for a brief introduction, is Edwin B. Parker Professor of Comparative Law at Columbia Corporate Business and Transactional Law, and she publishes and writes widely on topics such as corporate governance, money and finance, property rights, and comparative law and legal institutions. So, this very early morning on her side to talk about this very exciting book, The Code of Capital. This book examines how all kinds of assets such as land, private debt, business organization, or knowledge and ideas are transformed into capital through private law, and how the boring, technical, and apparently harmless work that we lawyers do day in, day out actually turn out to have all this systematic and fundamental contribution to the unequal distribution of wealth in our world, right? So I think now this book, I think since its initial publication in 2019, has been very well received within and outside of the academic world. It was named one of the best books of 2019 by the Financial Times and Business Insider. I understand currently there's a Chinese translation currently in the making for the readers from mainland China. At the moment, we really look forward to that. But even before that, for those of us in the academia, so for us who have already had a chance to read the English version, so far as I'm concerned, the feedback I have heard about is overwhelmingly positive. It's basically everybody recommends to everybody else. Everybody should read it. But also I think, as Professor Pistor mentioned in this book, so this is not a work intended only for legal scholars or legal practitioners, but actually it's for everybody who's interested in this very important topic about how we get to where we are in terms of finance, wealth, and inequality. So I'm sure this is a topic of great interest for the general audience in China, as well as, of course, in particular for the audience tonight. So I'm about to turn it over to Professor Pistor, but before that, I would also like to note that tonight, after the presentation, we do have some time for Professor Pistor to respond to questions from the members of the audience. So I will probably start the Q&A session with a question from myself, but also a question that we have collected beforehand from some interested audience. And then I will also be more than happy to read on behalf of our live audience, so all of you, a question that you might want to type into the chat box while the session is ongoing. So please feel free to type whatever question you have on your mind. In case there are too many questions, I will probably exercise my privilege to pick some. But otherwise, we welcome all kinds of questions. So without more, now please, Professor Pistor.
Thank you so much for this very kind introduction. Thank you everyone who has joined us for tonight in Beijing, early morning on the East Coast of the United States or wherever else you might be. It's really a great, great pleasure for me to introduce the book to this audience, to Princeton University book readers in China, and of course to followers of the Columbia Global Center in Beijing. I would love to come back there and do this in person. I've been at the center years ago, but of course travel restrictions currently don't allow us to do so. So I'm really, really happy that we can do this online. So thanks for joining. I thought I'll just give you some conceptual overview of the book, just introduce the core elements of my argument, apply it to a couple of legal scenarios, and then draw some implications from that. I should start by saying that I'm, of course, standing on the shoulders of many giants. Some of the earlier questions we have received asked about Marx, and there's, of course, Polanyi, there's Max Weber, there are many other social theorists and theories of our economic system called capitalism built into the book. But as has been said already by Shindai, I'm trying to write or reach an audience that breaches lawyers, economists, social scientists, humanities. And I was trying to write a book that would be accessible to all. So many of the big debates that are hidden in the book are referenced indirectly, sometimes directly in the footnotes, but I don't debate everyone in detail in the book itself. So let me tell you the big argument here. What is capital is one of the big questions that has been asked time and again, and it's somehow a conundrum. It has received different answers. The simplest answer perhaps is that capital next to labor is one of the two factors of production. But capital, of course, as we know, has certain features that are not explained by that definition, namely that somehow capital can generate wealth and protect the wealth of the capital holders, of the asset holders. So I'm basically saying capital is a simple asset, by which I mean either an object, a piece of land, an object like a machine or a car, plus its legal coding. Doesn't have to be a physical object. It can also be a claim to future payment. It also can be an idea, an invention. It can be an intangible asset. And that's when things really become interesting, because then you have basically an asset that itself is the product of legal coding, becoming a capital asset through additional legal coding. So a simple interest, object, or idea can be transformed into a capital asset with the right legal coding. What does the legal coding do? It grafts certain legal attributes on that asset and thereby privileges the asset holder. There are 4 attributes that I identify in the book: priority, durability, universality, and convertibility. You basically need 3 out of 4 to turn a simple asset into a capital asset. Priority ranks claims of different claimants, different people, to an asset. So some might have a property right, some might have a collateral interest, some might have just a contractual interest to receive something from an asset or from the asset holder. And law ranks these different rights. So that's what priority does. Durability is much less often talked about, but it's really important because it extends the interest of the asset holder over time. It does so by protecting the assets from too many different claimants. So on the one hand, we rank, on the other hand, we also shield. And the most important asset shielding devices, as I will explain in a second, are corporate law with a legal shield, a legal personality built in law, or trust law, the common law trust. Universality means that these rights that we have coded, the ranking, the durability, will be enforced not only vis-a-vis parties who have been at the table when we did the original coding, but against the world. And that's what state law does. That is why the state and its law is so important, because it enforces these legal rights and interests and privileges against anybody, whether or not that person had known of that particular coding. Once you can show that you have title, once you can show that you have a particular right, the state, its courts, its regulators will enforce it. And as I will mention later on, not only one state, but typically multiple states. And that extends the coding that we do in one country to multiple countries around the world. Last but not least, we have convertibility, which is really the way in which financial assets attain durability. So durability really means we want to protect what we have already against too many claimants, or we want to lock in past gains. And convertibility means that you can take an asset that a private issuer has issued, a debt instrument, a share, and of course that includes credit derivatives, et cetera, and you want to convert them in times of crisis in particular into an asset that can hold its nominal value, that doesn't lose its nominal value in the midst of a crisis. And the only asset really that can do that is state-issued cash. So when we say everybody's running for the exit, it basically shows you that what the investors are doing now, they're trying to convert their privately issued assets that have allowed them to make gains in the past into an asset that is safe. If I can do this as a legal right, if I have access to a central bank that will do this, or even to a private party that has committed to make a collateral payment or a margin call, then I have a greater likelihood to survive the next crisis, to lock in my past gains and insulate them from further decline in value. So once you have this concept, you basically say you have priority rights, durability, universality, or instead of durability, you have convertibility. And then you ask yourself, well, what legal devices can help me do that? And if I look historically, I'm basically saying we've had a handful of plus, maybe 6 legal devices, all in the area of private law that have done most of the work over the last 4 centuries in Western legal systems. Now I'm saying most of the work because you can show that other legal devices have been used. You can sometimes substitute different legal devices. You can also use legislative intervention and incorporate some of these priority or durability functionalities in other laws. So, but I think historically, these have been the most important one. Property law, of course, is the land enclosure. You're creating title and you're allowing those who have title to exclude others from access to the asset, whether it's land, whether these are machines, whether it's your car, whether it's your home. Collateral law is, of course, part of the property law regime. It basically says that I can have a right to enforce against an asset of my debtor should that debtor be unable to pay her loan. It is also a priority right. We're ranking claims. You're an owner or you're collateral holder if you have an unsecured creditor in times of bankruptcy. When we really test who has the better rights, then you will get a haircut. I already mentioned that trust law and corporate law create these legal shields that allow us to protect asset pools, entire asset pools from too many claimants. I will say a few words, more words about this when we come to the cloning of legal persons, as I call that chapter in the book. Bankruptcy law is somewhere in between. It is, of course, mandatory in most jurisdictions, but it is also a source of priority rules. Every bankruptcy code stipulates in what order creditors will receive whatever the debtor might have left. And bankruptcy law is so interesting because this is a situation where we know the debtor doesn't have enough assets left over to pay everybody. So where you rank, how you rank is really critical. The priority rules matter. And so do bankruptcy safe harbors and other rules that exempt some asset holders from the operation of the ordinary bankruptcy law. That's another way to create quasi-property rights or to create priority rules. And then last but not least, contract law, of course, is the paradigmatic legal device to organize relations between 2 parties in a horizontal fashion. And yet we can also use contract law to recreate many of the aspects of property law in particular. Today, in particular, with the information technology, we can create mass contracts that have almost universal reach by forcing everybody who wants to use my platform to click agree before they use it, and then I extend the contract to everybody else. We also see, and I will say this in a few moments as well, when we have complex contractual structures and debt covenants that are managed by a trustee, we can also create contractual relations that will bind thousands and thousands of investors who buy a particular product simply by buying that asset on the market. Okay, so why is law so important? And why am I saying actually it is law that codes capital? It is the DNA, the genetic code of capital assets. Well, because in the end, everything hinges on the ability to actually enforce my rights. I can make you a promise to give you $1 million tomorrow. There's no way you can do anything with that unless you're a thug and you come over and you try to extract it from me. But there's nothing else you can do unless it's actually a legally enforceable claim. And you can't support scalable national or even global financial markets in particular, where people trade with one another without knowing each other, without really verifying exactly who the original issuer was, unless you have a system in place that ensures that if I have a particular asset, I can enforce it. Now, enforceability, of course, doesn't mean necessarily that you can realize your claim. It may turn out that the debtor has nothing left by the time that you try to enforce, or you can't sell the asset fast enough because others have fear that you may not be able to enforce that claim. But nonetheless, there's a huge difference between having an enforceable claim and having an empty promise. So I think of the state and of state power basically as the centralization of coercion. And we have institutionalized the centralized means of coercion in a particular way. And here I want to say, I'll make it clear that this is an evolution that is germane in particular to the Western legal systems. It has been transposed from the West to other parts of the world. But China in particular has a very different legal tradition. I did study Chinese law in 88, 89 in London at the School of Oriental and African Studies. So I studied a lot of the history of Chinese law, and I'm aware of the fact that of course, there were private relations. Of course, there were merchants that traded, and they also had the magistrates very often enforced their contracts. But most of the legal disputes, other official settings, were viewed through the lens of what to a Westerner looks much more like an administrative code. But in the West, I think it's really important to realize that private law is key, and private law very often precedes what we now call state law. So lay people might often think of law to be primarily an instrument by which the state dictates or tells the citizens what to do, or perhaps law can be used by citizens to protect their rights against the state, which is also interesting. You take something that is of the state and protect your rights against the state in that fashion. But what I'm focusing on mostly is the way in which citizens organize their private relations with one another by using state law. They basically take decentralized access to the centralized means of coercion to organize their horizontal relations. That's what property law, contract law, collateral law, that's what all these institutions do. So what I do in the book essentially is I walk through how different types of assets, the objects, claims, promises, ideas, have been coded in law at different points in time. I always try to bring examples from the present, but also trace the historical evolution, because there are two things that are really important. One is that the legal modules here on the right have been almost the same for centuries. Now we tweak them at the margin. Corporate law comes a little later. Bankruptcy law comes a little later. Trust law in England goes back to the 13th century. The predecessor of the trust is the use. Property law is old. Collateral law is old. Contract law is old. We adapt them a little bit over time, but the basic essence of these institutions doesn't change so much. What changes is the assets to which they're being applied, or the assets that we create with them first and then apply them to dress them up as capital. Okay, so I want to say, just basically focus on two of the chapters that really apply the framework that I gave you earlier to specific types of legal devices. I want to talk here about cloning legal persons and then of minting debt. So cloning legal persons. We of course all know about the corporation, which is a legal person in the law. Economists always want to say it's a legal fiction, and Jensen and Mackling wrote a famous article in 1976 and said it's really the corporation is a nexus of contracts, and the legal stuff around it is more fictitious than real. And yes, of course, it's a fiction, but that's what our complex social systems are all about. We're creating the fiction that there is a legal person that can own its own assets, contract in its own name, sue and be sued in its own name. And the important implication of all that for capital is that we can create different asset pools that are owned by different persons, even if they're economically a single unit. So if I want to protect some of my assets against my creditors, I can transfer them to a trust or corporate entity. That means my personal creditors cannot access them. Now, if I do this when I'm already insolvent, they will be able to access them because that's fraudulent. But if I do this as a general asset management tool, I can separate my assets in that fashion. That corporation can create subsidiaries and further subdivide these assets. This has costs and benefits, but for my purpose of saying we can create durability, that's the most important functionality. I exclude certain types of creditors from a particular pool of assets, and in doing so, I protect these assets over time. They can incubate, grow, and multiply much easier if there are not too many creditors that can put their hands on them. So what we see basically in the context of corporations is that we combine different legal modules, corporate law or trust law, with priority rules that come from property law and contract law to create complex legal persons. The example that I have in the book is Lehman Brothers. I'm sure you're all familiar with the name. It's the investment bank that was forced into bankruptcy or went into bankruptcy in September 2008, thereby triggering a global financial crisis. Lehman Brothers is a really complex entity. I'm just going to give you this picture here, which understates the real complexity. Lehman Brothers had over 200 registered subsidiaries and hundreds, if not thousands, of additional so-called special purpose vehicles, which are very often trusts, at least in the Anglo-Saxon world, that can be organized as corporations as well, or other entities. But the interesting thing is that these legal entities were not in all kinds of different jurisdictions. They were in multiple jurisdictions, but there were 60 legal entities, 60 entities in Delaware alone, over 30 in the UK, over 30 in the Cayman Islands, some in Germany, some in France, some in Australia, Japan, etc. So you have to ask yourself the question, why do we have 60 subsidiaries in Delaware? We know that Delaware has a great corporate law, but it's not that great that you need 60 separate corporations in Delaware. And the reason is, of course, is that we do asset shielding. What Lehman essentially did was it created for almost every new product or functionality in a unified economic entity, created a separate legal entity that would undertake a particular task. It would raise its own debt finance to undertake that task. And the parent company, Lehman Brothers Holding at the top, would guarantee that debt. Now, the assets that the holding company owned were the shares in its subsidiaries, pretty much nothing else. So you're taking the shares and subsidiaries to guarantee the loans that the subsidiaries take on. The creditors thinking that they now know exactly what this subsidiary does, so they can monitor it better than if the money all goes to the holding company, assuming that the holding company has a lot of assets to back it. But of course, if the holding company has nothing but all the shares in the different entities, and the different entities are undercapitalized, then you have a problem if the market changes. And of course, that's exactly what happens. So what is interesting here when you think back about asset shielding is that Lehman Holding effectively waived its ability to shield its own assets from the creditors of the subsidiaries. But the really important story, of course, is that, first of all the profits from the subsidiaries flow back to Lehman Holdings. And then, of course, Lehman Holdings paid all that out to the shareholders. That's what I mean by a money mint. You're basically using all the profits that have been created by the subsidiaries, which are undercapitalized, which basically use debt finance, plow back all the dividends to the parent company. The parent company immediately pays them out to the shareholders. That's how they made money. Many shareholders got stuck in the end. If they didn't sell in January 2008, they had a problem. But before that, they could make a lot of money in Lehman and elsewhere. So did many of its top managers and shareholders who stayed to the end. In the end, they had made quite a bit of money in that fashion. So I'm aware of time, and Shindai, please interrupt me if I go really over, but I just want to push on and go to the next chapter, minting debt. Here I want to talk about asset-backed securities. Of course, these are the assets that were at the very eye of the storm of the 2008 crisis. Asset-backed securities are still with us. There are many good stories you can tell about them. They can help you diversify risk. They can lower the cost of credit finance, and thereby make loans more accessible for many people around the world. So this is all good. But let me just walk you through this and really show you again how my different legal devices and the attributes of these legal devices work in a complex setting, a highly oversimplified complex setting, but nonetheless. So we start on the left-hand upper corner here, and these are little houses. They're owned by homeowners in California. NC is New Century. It was a mortgage originator. So you have a separation already of functionality between a bank and a mortgage originator that was giving loans to homeowners, taking a mortgage to collateralize, right? To create a priority right for the creditor vis-a-vis the house of these debtors. They would originate thousands and thousands of loans backed by mortgages in California, put them all together and sell them wholesale to a big bank such as Citi. Citi itself is a major conglomerate. It looks just as complicated as Lehman, if not more so. One of its affiliates buys this package of mortgages and then transfers them into a trust. This is here the RMBS trust. The little flags, by the way, indicate which jurisdiction we're in. So this is New York. We have a trust. Why do we have a trust? Because we want to shield the assets in the trust. We want to make sure that the investors who are buying interest in the trust know that they don't have to worry about Citi, because the trust is a separate legal entity. So the investors who ultimately buy the cash flows that come from the homeowners here, they don't have to worry about Citi, they don't have to worry about New Century. All they have to worry about are the assets in the pool. And that makes it more attractive for them because they think that they can know what these assets have. Now, originally, when we looked at securitization of mortgages in the 1970s, when the government-sponsored entities, Fannie Mae, Freddie Mac, Ginnie Mae, did the securitization, they typically had very simple structures. You would basically cut the trust into different slices, and people might buy a bigger slice or a smaller slice, but they would have all the same slice. Once the private sector took over the securitization business, they realized that they could use contracts to tranche, with the French verb trancher for to cut, to basically change or create different cash flow rights for different types of investors, to basically tailor the claims that different investors may want to buy to their interest, how risk averse they are, how much yield they want, et cetera, et cetera. So when you break down who bought the tranches, the different slices to this particular trust, you find that the super senior ones, the safest ones that give you the best guarantee to get the money that you want, go to Fannie Mae, a government-sponsored entity that no longer does the securitization, but buys into the securitization structure. Here, China's investment company, a sovereign wealth fund, is involved. Germans, Bayerische Landesbank, also state-owned bank, BNP Paribas, French private bank, and they all buy the senior tranches. I didn't put up the junior tranches. They go to all kinds of investors who have interest in risk and want the yield. We always have one particular problem in the securitization structures, especially when we have many of them, and as the market boomed, we had many of them, which is that the mezzanine tranches, which are in between the safe and the non-safe claims that you're buying, were difficult to place. They were not safe enough for those who wanted safety. They were not risky enough to really produce high yield. So the industry came up with the CDOs, which is basically another corporate entity now, here incorporated in the Cayman Islands. This is Claros. Claros also had a sibling in Delaware, but I'll just ignore this for a moment. So Claros was set up to buy the mezzanine tranches from this NC trust, this trust, and many other trusts. So you have, again, a diversified portfolio that you throw into another legal shell, and you sell interest into that particular legal shell to different investors. Again, you have senior, junior, and then you have the mezzanines. And if nobody wants to buy the mezzanines, you're creating CDO squared, and then you go through it again and you do CDOs cubed if you have to. So they're legal devices to cut the interest against future cash flows such that you can find still investors who are willing to buy into them. That's the beauty of the scheme. And when you look through this entire scheme again, you have property rights, you have collateral law, you have trust law and corporate law, you have contract law. We'll use contract law to tranche, right? We have all the elements of the legal code. Of course, we also have built in, I didn't say much about this, bankruptcy safe harbors for derivatives that make it even more interesting for investors to buy into them because they get privileged treatment if bankruptcy should ever happen. Now, it didn't work out how people had planned this. We know this. We also know that the bankruptcy safe harbors fueled the exit from these assets in the time of crisis, but ex ante, people believed that they would be safe, and that made a huge difference for them to buy into this. Okay, I think I will skip over the digital code, but I want to throw out the notion that I have an entire chapter, chapter 8, that asks the question whether there is a new code that might replace the legal code. And I'm talking a little bit about smart contracts, about attempts to create digital autonomous organizations, digital currencies. And I come out basically in this, I finished the book, I should say that, in the fall of 2018. It was published in May 2019. So at the time I came out and suggested that I believe that the digital code is most likely to be enclosed by the legal code. So there will be a lot of digital efforts, but they will be subject to legal regulations, public regulations, but also private law, because you can't do everything on digits that you have to do then also with the law. There are lots of reasons for that. I'm also changing my mind a little bit on that. I'd be happy to come back to this in the Q&A, but I think I would take up too much time if I went into the details here. Let me instead hit on three more topics. One is global capitalism. The second one is the role of the lawyers. And the third is self-governance, democratic self-governance in particular at the national level. So the globe. I told you that capital is coded in law, that private law devices code capital, and yet private law is national law. We don't really have a global private law. We don't, even in the EU, we have relatively little harmonized private law as compared to what nation states still have themselves. And so here's the puzzle. If I'm right and capital is coded in law, and in particular in private law, then perhaps we shouldn't have global capitalism, because we don't have global private law. We don't have a global state that enforces it. And my answer to this puzzle is that in theory, we could have a single domestic legal system offering the law in which capital is coded everywhere in the globe, as long as all other states recognize and are willing to enforce this foreign law. And as I'm saying, basically de facto, we have two legal systems that dominate the coding of capital, have always dominated the coding of capital, but especially today in our world where much of global capital is really financial capital. And this is the English common law. So I'm not saying UK law because it's not Scotland with its civil law system. It's really the English common law that produces the property law, the contract law, collateral law. And that's the core of it. And US law, in particular, New York state law, mostly for the financial and contractual property rights aspects, and Delaware law for corporate law. But there you can throw in a few more. We could really say US law. This works because most other jurisdictions in the world will recognize and enforce the legal devices created thereunder. There are, of course, debates, but I think overall we have pushed back the debates. And the instruments for doing that, and of course the lawyers amongst you will know this, but for the non-lawyers, this is a world that is not that well known, is that we use conflict of law rules to make that happen, right? So a corporation that is incorporated in Delaware is a Delaware creature of the law, but it can do business anywhere in the United States. It does not even have to do business in Delaware to be recognized in Illinois or to be recognized in either Israel, Germany, France, or England for that matter. Now, Germany has said for a long, long time, but can no longer say this very loudly under EU rule, that it will accept a foreign corporation as such only if it does business elsewhere. If it has its headquarters in Germany, wants to do business in Germany and has its headquarters in Germany, it must be incorporated in Germany so that Germany can dictate the terms of corporate law, including codetermination, for example. But the European Court of Justice has basically told Germany that this is against the free movement of persons and capital within the EU. And so Germany has to recognize corporations, at least from the other member states. It can still make it difficult for its own corporations to move elsewhere. But the idea that countries basically retain their legal monopoly over corporations has gone out of the window, and for financial assets, that's even true for property law. Now here, this picture shows you, of course, the two leading global financial centers. There are competitors out there, of course, especially from China, right? In the background, we still have Singapore. We have Hong Kong, has always been also a contender, but Shanghai, Shenzhen are others that people are watching in this space. But I think most would still agree that London and New York are still ahead of the game. What people are not talking about so much is that both London and New York are also the hubs, the home for the top global law firms. And global law firms are typically defined as law firms that have offices in at least 2 jurisdictions. So I just gave you the top 15 global law firms from 2019. And as you can see, almost all of them are either UK or US. Denton's is Chinese, but it also results from a merger of English, American, and Chinese firms. And so it doesn't really counter my argument, which is to say that the global law firms are actually Anglo-Saxon firms, and that globalization, understood as I understand it, is basically the expansion of domestic legal devices to other parts of the world, is really an expansion of Anglo-Saxon legal practice. And so I call in the book the lawyers the master coders. Since we use law to code assets, you need lawyers to do the work. What lawyers effectively do is that they take legal devices that have been well recognized and try to twist them and tweak them and adapt them to code other types of assets, or to create new types of financial intermediaries or other vehicles that can be used to legally ensure that their clients have a comparative advantage over their competitors. The whole point is to make it legal, right? A lawyer I teach with very often at Columbia, one of our trustees, basically explains to my students that you have to think about existing laws and regulations as the legal scaffolding. And when you create a new legal structure, you're trying to create a device that fits through the gaps of the scaffolding. You don't want to have a court strike it down. You want to make sure that it's legal. And so it has to fit through the gaps. And that's what lawyers do. And of course, in the global world, they very often have to use the legal devices from one jurisdiction, like from the UK or from the US, and fit them through the regulatory requirements of other jurisdictions. Many investment banks, other financial intermediaries are subject to multiple regulatory regimes. And so this becomes a real work of art to be able to do that. So it's sophisticated. It takes a lot of efforts. Lawyers would typically argue that they're in the packaging industry, that they only package the interests of their clients and don't really have much agency here. I'm basically saying none of that would be possible without the lawyers. So that's why I think they're the masters of the code, not of capital. They're the masters of the code that creates capital, which gives them a lot of power. Okay, so this then raises the final question is, who governs? Who governs whom here, really? And obviously, law in complex societies is the way by which we govern ourselves. In democratic societies in particular, we want to say that we elect our representatives and they adopt the laws by which we're governed. It's not some higher up or dictator or somebody who tells us how we shall be governed. Now, if we code capital by allowing private parties to pick and choose from a menu of different legal systems, the rules that best suit their clients' needs, which may be from this jurisdiction or that jurisdiction, obviously we're undermining the ability of national legal systems to govern themselves democratically or otherwise. So there's a tension between the scope of private autonomy that private parties have and the ability to collectively self-govern. And that's a tension that we've always known, but I think it's really coming to the fore because we have largely outsourced the coding of capital over the last 30 years, mostly by relaxing the conflict of law rules, but also by reducing entry barriers for capital flows, et cetera, et cetera. So ultimately, I think the ability of some who have access to the lawyers to opt out of domestic legal systems erodes the legitimacy and efficacy of domestic legal system and creates problems of self-governance over time. Now, let me just say, and then I'll really stop so we have some time for questions and answers as well. I have a chapter in the end that does ask the question, basically, that, the famous Lenin question, "Что делать?" What shall we do? About this, and I'm basically saying we have to recognize that the system that we have created is a complex system. It has evolved over time. I'm showing certain patterns and regularities. We have to understand them, because only by understanding them can we push back and understand where actually capital as coded right now is vulnerable and how we better strike the balance between self-governance and private autonomy. in the future. So, for example, I'm not convinced and not persuaded by Piketty or Zuckman and colleagues who say we'll just do this through taxation. Because if there's one thing that lawyers have done for the last several centuries, they really, really have learned how to deal with tax obligations. One of the biggest creditors is the state, always, for all private actors. And to get around that and minimize tax implications is one of the ways in which lawyers have always helped their clients. So this ex post redistribution is not sufficient. We have to think about the creation of wealth ex ante, the pre-distribution, as some say. So I'm basically suggesting a couple of things to think through. It's not complete. It's part, of course, of my future research. But for example, bright line rules to not add on additional privileges on all the rights that the private sector already has. So I'm not a fan of bankruptcy safe harbors or any other safe harbors, if you wish. Limiting law and choice of forum for things that are really important for a country to do. So I think we have to rethink the extent to which we use the incorporation theory for corporations without allowing states to impose some additional regulations on companies that do most of their business in their jurisdiction. Same for arbitration. So I think I'm basically saying we have to roll back the extent to which we have outsourced to private parties the ability to pick and choose the law that they like best. Basically, we have commodified, if you want, privatized the law. And law is not a private commodity. It's really a social governance tool. And it's the only tool that we still have. Maybe we have to wait for the digital code, but so far it's the only tool that we have to govern ourselves at scale. So let me just leave it here. Thank you very much for your attention, and I'm very much looking forward to your questions.
Okay, thank you. Thank you, Professor Pistor, for such a actually very concise and very well timed, and also a very illuminating presentation of the main arguments of the book. I think before we turn to audience questions, which I see there's already one in the box, and I encourage people to continue to post them. I would first just abuse my position as a moderator a little bit to share some initial thoughts and also ask the first round of questions, I think, while we're waiting for audience questions. So I think, first of all, I would say I really appreciate that Professor Pistor endeavors to shed such a very sharp light on the role of the state behind private law, which I think is a little bit different from the mainstream Western legal theory that we are familiar with, right? So the traditional theory typically try to make the role of state to stay in the shadow or even in the dark when it comes to private law, right? You know, contract, property, corporation, trust, and so forth. So I guess the idea is, you know, it's been a long tradition or inclination for lawyers to accept or even promote this very idea that private law derives from some sort of, you know, natural, neutral, objective reason, right? So of course, we always had very smart people telling us that's not the case, right? So in the German text, it's, you know, either it's Karl Marx or, you know, even just Rudolf von Euring. In the US, we have Oliver Wendell Holmes, legal realist, so forth. But still, I guess it's very influential among lawyers, right? So this idea that at least to some extent, our mindset is that private law, as opposed to you know, public law, is neutrally mediating private arrangement, and therefore is largely apolitical, right? So I think what this book does really nicely is a very great reminder again of the fact that there really isn't anything I would say natural about the private interest, private assets, private capital that is being protected and promoted by private law. So the necessary features of capital, as the book introduces or summarizes, priority, durability, universality, convertibility, these are all legal creations. But I think what this book has done so nicely is that it really shows us, the readers, how the law actually or mechanically does it, right? Creates all of these, and it illustrates the mechanism very well in such an illuminating but also very accessible manner. So this is really great work. So now, while I think at the general level, I do agree with this theoretic framework, it's very important. I think I would just comment from the Chinese point of view that for those of us who are familiar with, or actually a part of the relatively recent Chinese experience of their impression, I mean, by no mistake, has always been that the state plays an extremely instrumental and also salient role in terms of laying down the legal foundation of capital. So, of course, most recently, China has enacted a comprehensive civil code. A lot of people say that's a big deal. But I think, importantly, at least since the early 1980s, right? So the contemporary private law institutions, namely the basic principles and rules of contract, property, business associations, intellectual property. So all of those have been put into place as a result of very well understood state agenda, determination to attract foreign capital into the country so as to jumpstart the market economy, right? So, and ever since then, I think there can be no mistake that it is the state itself in China that is, or that has been consciously and unequivocally supplying all the necessary kinds of tools and infrastructure of private law to facilitate the creation and growth of both state and private capital. So I'm saying this I didn't mean that, of course, the private lawyers have not had played some sort of similar active or proactive creative role as described in your book. I think indeed, because in China, the state has tried to put everything in place in such a short period of time. And meanwhile, the economy develops in such a has-been speed, right? So the lawyers actually indeed played a very large role, and also they have a considerable room to do that, right? In terms of working on all these minutiae details of private transactional structures that the law itself doesn't or wouldn't be able to have provided for concretely, right? So I think even though from the outside, maybe the perception is the state and the legal profession, the relationship being contentious from time to time in China, but actually I think when it comes to coding capital, there is quite a lot of synergy or coordination, between the two forces, I would say. So one very good example might be a couple of decades ago, for example, when the Chinese firms started to try to seek access to the international capital markets. And then there are all these kind of restrictions on foreign shareholding in certain sections of industry, internet, financial services, media, so on and so forth, right? So it is actually the lawyers try to work out lots of very ingenious, transactional structures to get around all these restrictions, right? For example, to use contractual relationships to afford foreign investors control over domestic assets in a way very similar to shareholding, but just not called shareholding. So these are, of course, I think there are a lot of other, examples in similar spirits, but I think what's remarkable here is that the state knows very well what's going on about all these coding strategies. And they pretty much give a free pass, or at least for quite some time, even implicitly or tacitly encourages all these, workaround codings, right? So I think these examples from China suggest the state may choose to behave very strategically in terms of the stance they take on what the private law says and what private lawyers do, right? So I guess on one hand, this observation may not necessarily be all identical with a situation where the state seems to be a little bit aloof with respect to what takes place in the world of private law, right? Or how their power of enforcement is being leveraged by these private parties. But I think in the end, this observation also supports your claim that we should really reconsider what the state should do toward the private law, because there's just so much they can do, right? So, but here I think I would pose the first question for discussion here, which is, I guess there is one underlying dynamic here or tension here, which is given that the uneven development and distribution of wealth across the globe, right? So I think underdeveloped or non-Western countries, they will always have the incentives to enact or accept or adopt private laws that are favorable to foreign capital, so as to attract them into their country, right? So do we think there may be some kind of pressures, of racing to the bottom, for example, on many states because of the existence of this dynamic, right? So, for example, many states, they may otherwise be interested in changing the code of capital within their borders towards greater equality, but then worry that if they do that, it might get them to a disadvantaged place in terms of competition for outside capital, right? So this is the first question I would just pose so that we can start the discussion. Thank you.
Well, thank you so much for your comments. I really appreciate them. Let me just say a few words of what you said before, and then I will answer your question. First of all, as I mentioned before, yes, there are lots of people who have come before me who have said similar things. I mentioned the old institutionalists, of course, the realists in this country as well. I'm basically bringing this debate to the 21st century, and as you suggested, I tried to make it accessible also to non-lawyers and to really show how it works today in a really sophisticated fashion. The other point I want to comment on is the history of China more recently. I was actually a student in 88, 89, not only of Chinese law, but also of Soviet law. And of course, in the fall of 89, and the wall fell. And I spent the next 10 years mostly researching Russia and Eastern Europe in the transition that they went through, always also with an eye on China. But I don't speak Chinese. And so that's the decision I made at some point to focus on Russia and study Russian. But what you can see so very interesting in this comparison, when they did mass privatization and transformation in Russia, they did this without a legal system in place. And the economists learned this only ex post factors. So the people who then launched the law and finance literature, Andrei Schleifer and others, had done mass privatization before they understood that you can't privatize a state-owned entity without a corporate law in place. Right? So I think in that sense, the gradual approach in China was much smarter. And I think China also decentralized the way in which people tested out different ways of organizing the economy, companies, etc., and then nationalized the solutions that had come up. It is a choice by the state or whatever the legislative authorities are, which are the rules of the game that shall prevail, right? And these choices are made in every society. The reason that we are where we are in the West has a long tradition in the common law, in particular, the way the legal profession has been organized and served its private clients, but also political choices that we want to give this authority to private parties. But as you suggest, what we should not forget is that these are choices and that the state backs these private parties. It's not outside the law, it's squarely inside the law. So this is really an important point. Which then brings me to your question about sort of other countries, what choices do they have? Now, as you know, the World Bank and other multilateral organizations have worked very hard on disseminating the best practices of the Western economies to the rest of the world. If you look at the doing business indicators that came out again in the fall, they have come out for the last almost 20 years. What the World Bank is measuring is the ease with which business can do business in a particular jurisdiction. It is not measuring necessarily what other social objectives might be out there. And even though there might be a correlation between protecting property rights in some ways and economic growth, we also have to be concerned with, and I think people are becoming increasingly concerned with the distribution of wealth inside the country, not only the country as such growing. So to the extent, what are the choices that different jurisdictions have? I think China is an example of a country, and of course it's a big country that has made quite consciously choices that are different from what many other countries have done. So it's possible, but you have to have the heft. You have to have both the market power and the political will to go a different path. There are other smaller countries that have done this from time to time. If you think about Malaysia's response to the East Asian financial crisis after 97, 98, basically said we'll just stop capital inflows and outflows in particular, but inflows as well for a while, so we can stabilize. We will not do an IMF program. So I think what I find important is that also policymakers in different countries realize the interaction of private law with social objectives and think about how best to balance that. I'm basically not saying roll back everything. I'm not saying nationalize everything. What I'm saying is that we have to strike a balance that gives policymakers enough space to do what is right for its people.
Great. I think this is actually is a good segue to our first audience question, actually. So we have a question from Wu Shuang. So he's also a law professor. So his question is really about the big ideas in the background, lurking in the background, right? So he was quoting you in the book, saying that you argue in the book it is possible to explain the political economy of capitalism without having to construct class identities. But he thinks the key to understanding capitalism lies in the legal coding process rather than production or exploitation or labor. So that's what he believes you argued. So he said, I came across a thought-provoking review on your book by Adam Toozy the other day. He wrote, what is at stake in your analysis is the distribution of surplus within the capitalist class. For the surplus value which changes hand on the exchange is surplus value already in existence. So the product past exploitation of labor. So according to Tuzi, your book gives so much space to Wall Street stock exchanges, so little to production, labor, and accumulation. So he wondered how would you respond to Tuzi's comment regarding labor production and all these inequality, the basically the Marxist line of theme here.
Yeah, I think the way I read the neo-Marxist literature in particular is that there's always an attempt to show that ultimately the capitalism is about the exploitation of labor, and that we have to find the surplus typically in labor. So sometimes people go back to pre-capitalist societies like agriculture and say actually this is also proto-capitalism because we're extracting value from labor. What I think we're doing today is we're not so much extracting value from labor, but we're extracting value from society. So if you think about financial capital, you don't really need that much labor for that. What you need is a good lawyer who tells you how to code the capital, how to create an asset that can be easily traded, that will find buyers, and where you can shield different assets from access. What they're doing, of course, is they're doing this on the back of our safety system, of the financial system, and they're doing this on the back of central banks being willing to provide them with liquidity if and when needed. So the extraction is still present, but it's not from labor as a class, but it's from society. That's sort of one point. The other point I wanted to make is that that the class structure seems to be too rigid for me when I look at the history through my lens, because what you can also see is that you can have new asset holders who become wealthy and can have their assets coded as capital by finding the right lawyers to do so. So example, England, when land was no longer the most important source of wealth, and that was also a legal change that was done in the late 1880s, lawyers simply used the same skills that they had earlier used for land and transposed them to financial assets. Now, I grant you that many of the landowners had also invested in financial assets. So you must have resources to have new assets. But when you think about big tech or many of the new startups, these are new ideas, these are new assets that are being created, and they become really to the fore through the legal coding process. So I think we have different mechanisms. I'm not saying labor doesn't matter. In certain contexts it does, but I think the attempt to always find this class struggle and to identify surplus extraction with labor limits our perception to a broader problem that we might be having, or just a mechanism that we have to understand.
Okay, great. But I think I would actually follow up a little bit on this question though, but in a different direction, right? So I think you the book is, the title is Code of Capital. So basically the keywords code and capital. Code means law, right? So I think you talk all these kind of law, mostly private law, but on one hand, so supposedly, so the public law should be very important in terms of wealth generation and wealth creation. And also even for private law, so it seems, so you haven't discussed, for example, I would say tort law, for example. That's a very big part of private law, and that also has a lot to do with, I say, liability shielding and then also allocation risk or wealth. So, and then for capital, I guess the related question related to the previous one would be financial capital, of course, is a big one, but then human capital, of course, that's where the labor law actually does a lot. In terms of regulating, and also relational capital or reputational capital, for example. So those might also be subject to the laws, regulation in terms of creation and promotion. So I'm just wondering, maybe your thesis, of course, can be extended to all these other areas, other types of laws and capital.
Yeah, I think it certainly can be extended. I think there's always a problem when something is over-inclusive and it loses tractability. So I'm a little nervous about this, but in principle, yes. Now let me just sort of say a few words about sort of the legal domains I chose. Why not tort law, etc. So I think tort law comes in also indirectly in many different ways, but I think it's not at the heart of how to create a new capital asset. So what I basically did, I took a look at the different sources of wealth that Thomas Piketty and his team had identified, and how they changed over time was land first, and they became financial assets mostly, and urban housing, which is also very much a financial asset. And so I tried basically to understand them through reverse engineering, which are the institutions that create that. But you're of course right, we can shield assets not only by corporate law and limited liability, we can shield assets also by different types of tort rules, and can do this either through top-down regulation or otherwise. When you think back to the 19th century, when railways and other new companies basically got limited liability shields, right? And we do the same with nuclear industry today. So that's another way to create wealth. Absolutely right. So and labor, you know, I think I'm not going to go as far as saying labor as such or social capital is the same thing. I think it's qualitatively differently, but you can see I can capitalize my own human capital, my own labor, by basically creating a limited liability company, contributing my work in kind, and taking dividends rather than a salary. That's how I do this. So it is possible, but I think we use the same coding strategies that I describe in the book.
Great. So next audience question. So this audience, so this is from an anonymous audience. So will there be different laws for digital capital migration from various countries and regions? So I guess this is a question about how different countries might actually, you know, provide, you know, coding tools for the new type of assets.
Yeah, I mean, this goes also back to another question you just asked. I think there's always this interplay, especially in finance, between the code, whether it's the legal code or the digital code, and the regulation. So the regulation, again, is the scaffolding that says, you know, this is, we have some bright line rules. You cannot do certain things. And then the idea is you have to fit your new assets, whether they're digital or legal, within the gaps left by the scaffolding. The important thing to realize here is that many of the new digital coders thought that they could do something completely outside the law because they didn't want to be in the law. Well, lo and behold, but you are in the law if you work in this world. So what they had to learn is actually what they were doing. For example, when you do an ICO, it's actually a security and then subject to US securities regulation. What they did in response, many went to Switzerland, is because Switzerland was more accommodating. Libra Association was created as an association in Geneva for a reason, because Switzerland was trying to position itself as basically the new London for digital assets. But when they want to come back and sell their assets in the United States, regulation remains domestic and financial regulation is pretty tough. So they have to negotiate with US regulators, whether it's the SEC or the CFTC or the OTC, about the conditions under which they can come back to the US. And what lawyers do is try to mediate this negotiation, make sure that they can create the new fancy assets that they have created under Swiss law. Now that they can bring them back to the United States without fearing regulatory impediments.
Great. Okay. So next question, also from anonymous member of the audience. So he or she asks, how about multilateral trade regulations such as GATT and WTO rules could be explained in this context with regarding to global economic governance?
Yeah, I think what the WTO is really, it's an interstate and intergovernmental, really international treaty. So it doesn't go to the basic modules of my code of capital, but it basically says you can't stop goods or services from coming into your country. And if you subject yourself to the WTO regime, you're basically saying also that you have to minimize the intrusion that you have about the legal creatures that bring these services to you. So it doesn't mean that you have to accept every financial service without it having to incorporate in your jurisdiction so you can govern it. But you have to open your borders to all kinds of different goods that might be coded in different ways. So it basically forces countries to roll back their scrutiny of the types of assets and the identity of the producers or service providers that come to their country. It doesn't eliminate them. I think it's still the core issues are still harmonization and of course conflict of law rules. The WTO doesn't go that deep, but it still makes it easier, of course, to breach the boundaries of different jurisdictions.
Okay, great. Okay, so while we're waiting for more audience questions, I'll just ask one for myself again. So I think I'm going back to the question relating to digital asset or technology. So basically, I think today, one of the very important sources of rules for private arrangements or conducts, as you described or mentioned, tend to come from very powerful market intermediaries. For example, the big tech companies, platform companies, right? So they are able to make rules for private transactions because they control information, communication data, and I guess predictive power, for example, so that all kinds of resources become attracted, aggregated on their platforms, right? So I guess it's interesting. So that in the U.S., for example, the law such as Section 230 of Communication Decency Act basically says they can set the rules whatsoever within their own terrain. In China, it's the same, right? So even though the perception is the state actually intervenes or stringently regulate internet in some area, but for quite a long time, the state has been very hands-off until very recently in the commercial internet transactions, right, in terms of regulating those. So I'm just curious about your view towards these tech companies or platforms like rulemakers, because it seems to me the platforms are combining the use of both computer code and legal code, right? So for example, even where the state refuses to lend property style protection over digital resources, these firms, they may be able to rely on technological barriers, right, to achieve the same sort of enclosure, over digital assets, right? So do you think, for example, the big tech may pose a new kind of threat or problem compared with the traditional capitalists, right, who only simply hire good private lawyers?
Yes, I think yes, I think so. So I wrote 2 papers over the course of last year, which have been published, one on rule by data, the end of markets, and the other paper is called Statehood in the Digital Age. So in Statehood in the Digital Age, I'm basically saying actually controlling our data and the ability to monetize our data, not only today, but also in the future, is a new source of power that is different from territorial power and might also create new forms of sovereignty. So, when you think about what gives the state the capacity to back its own currency when it issues its own currency, it's, in my view, the ability of the state to pledge our future productivity. If Facebook or Twitter or others, especially Facebook, the bigger ones, Amazon, have access to our data, how we behave in all kinds of spheres of life, and that's an economically valuable good, and they can monetize this in the future, they can also issue their own currency eventually, right? So that is a source of power, not only wealth, and you can use it in certain ways. So I think we have to be concerned about this. The second paper, Rule by Data, I'm basically saying once the other side, which is sort of the sellers of products and services, have all the information about how consumers behave because they buy the information from the big tech and then run their own algorithms, try to understand what we want and how we might want it, and then target us to buy this or influence our behavior in other ways, whether it's politically or economically. We're no longer in an exchange relation. The asymmetry between the two parties, between a consumer and a seller, is such that I wouldn't call this a market anymore. So we have this irony here. Remember Ronald Coase, who said he asked the famous question in 1937, why are we not only seeing markets? Why do firms exist if markets are the best way to organize economic relations? Well, you would think then, and the answer was transaction costs. Well, now we live in the information age. Transaction costs have been reduced to almost zero. And what do we see? Big tech, right? So there's a consolidation of power, economic and political power in these companies that I think we have to think very seriously about and very fast because it's a moving target. Now, I think we have, tragically in a way, because of the insurgency at the Capitol last week and the ongoing debate in the United States, we might be creating a real opening right now because we're rolling back the power of big tech because of the political implications it has had. But I think we have to push further because that I do really see this as a major concern. It's part of my ongoing research. Yeah, thanks for the question.
No, but wonderful. I'm definitely going to pull up these 2 papers tonight after this. Okay. Okay, so we have another question from Jeff New. So his question is, for young adults without rigorous legal education, how might we first improve our legal literacy surrounding wealth and the design of its system scaffolds? Second, how might we better design safeguards against the aforementioned unsustainable extraction of value from society. I would actually just piggyback on this question. I think, so this is because this is a larger question also actually for all of us, educators in law schools, right? So basically, I think your book really reminds us that lawyers need to have the big picture in mind, right? So in law schools, I think students aspire to become trained to do very sophisticated works, write and negotiate complex contracts, win difficult cases by making, creative arguments, playing with obscure legal concepts, minutia, technical distinction, right? So, and also we at the law school, we take pride in training students into such kind of sophisticated lawyers, right? So, but on the meanwhile, I think, especially as Jeff was asking, right? So not just for people who are not in the law school, not studying law, but also just for even for lawyers, right? How do law schools actually should train lawyers that could not only be the coders, but also be legal reformers, for example?
Yeah. I mean, first on Jeff's question about non-lawyers, I think one of the things I'm trying to do in the book is to unpack and to make things accessible. And I think more generally, we talk about SPVs and CDOs and CLOs, and when you take it apart, what you find is your contract, your property law, your collateral law, your trust law. You find all these elements put together, and then you put a nice label on it, and nobody knows what you're talking about. So I'm basically saying let's just do a little bit of anatomy, right, and discover the structures that are behind this, and then see what they do and how they do this. And you need some basic literacy, but you don't have to be a fully trained lawyer. Same for the digital stuff. We all don't know how to code. I don't know how to code digitally, but I think understanding basically what are the core entry points, how things are organized, or how they could be organized differently, and talk to technologists about this is really important. So I think we need more interdisciplinarity, but we also need to be clearer about what the underlying structures really are, and uncover them. On the law school education, again, I think, when I wrote this book, your editor always tells you have to have somebody in mind for whom you're writing the book. And in part, of course, I'm writing this book for my students, because I want lawyers to be mindful of the systemic effects of their work. We have trained them that they're not. We have even sort of trained them that they're no longer thinking so much of a legal profession, but they're thinking about maximizing the value of their clients. And I think this is wrong. So I talked to a lot of law firms, top-level law firms in New York after the crisis, because I had written a paper on the legal theory of finance, and talked to those who had done the structured finance in the years leading up to the crisis. And they were all sitting around the table and saying, we don't know how this happened. We work together with the smartest people in the world, and we don't know what has happened. Because they have this focus, they're blinded. And I think we have to be much more mindful in the law school, also to put the dots together and show them how different aspects of the law fit together in a certain way. But then not only that, you can create fancy assets with that, but what implications it has for society, for the world.
Great. Next question. So we have it from Songchen Yao. So Yao says, I'm fascinated by the idea of surplus value as legal creation, as opposed to physical existence, which was also raised in the first question. So could Professor Pistor elaborate a little bit more on how financial capital creation is fishing from the society in general instead of particular laborers?
Yeah, I mean, I think most of what we have nowadays in terms of assets and wealth is really an extrapolation of our social relations in one way or another. And in particular, those that are backed by the state are coded in law. So when I think about a financial asset, it's basically a promise to future payment put on legal steroids. I have an enforceable contract, I add a collateral, I add a, so I basically secure it by adding the collateral. I can also add a margin call or collateral call, which means that I'm trying to extract legal tender cash from another party if the value of the asset declines. And what is that? It's basically insurance that I create. And the insurance is then taking legal tender. All of our financial assets are denominated in hard currency, typically the dollar in the United States, globally the dollar very much, sometimes the euro, the yen, and other globally traded currencies. And that basically means that most private parties expect that they can convert the private assets into real money into the dollar at that particular price. Now, it of course very often doesn't happen, but when it doesn't happen, and we've seen this in crisis after crisis after crisis, is that the states typically do not stand by and allow financial systems just to collapse. They did this in the 1930s. The central bank in the US just, basically played by the rules and that we can't discount anything but real bills, so we will not. And the system collapsed. And in 2008, Bernanke, who was a student of the 1930s crisis, said we will not ever do this again. So we're basically backstopping the entire financial system. We will be the buyer of last resorts. They're not only the lender of last resort, they're the buyer of last resorts. That's how we extract surplus value. The private sector creates all these assets. Many of them are fixed assets with a defined term of what they're going to get. And if things don't work out, and of course they will not work out because we still live in a world of future uncertainty and not everything that you contract for yesterday will happen tomorrow. If things don't work out at a systemic level, there's a high probability, and everybody knows that, in particular the financial sectors, that the state will come in and offer cash where no cash was owed. If I give you liquidity, if I give you the money to pay your debtors, you get something. From whom do you get it? You get it from society, because this currency reflects our future productivity, the willingness, the ability of a state to stand in for its own currency, maybe even for its own debt. That's how we extract value today.
Okay, great. So I think I'll seize the opportunity to ask the question, which I think I was expecting people to ask, which is about your prescriptions, right? So I think one of the proposals you make toward the end of the presentation, also the book, is that you said there should be more bright line rules. So that simply reduce the more bright line rules, right? So that will simply reduce the room where lawyers can just do all these tricks and make it basically harder for certain coding the capital that are so complex and may create systemic risk, right? So, but I think one question I would have is, it seems that restrictive laws and regulations, whenever you want to make it simplified or you want to just make it rule-based as opposed to standard-based, in the legal jargon, the rules can never be watertight, right? And lawyers are always able or always there to engineer workarounds, right? So there seems to always to be the dynamic of cat and mouse, right? So in terms of closing loopholes, finding new loopholes, closing them, and then all around again. So that pretty much shadow the prospect of the incrementalism you're proposing, right? So this, at least my impression. So alternatively, wouldn't you think that, for example, principle-based laws and also the establishment of, let's say, capacious regulators, of course, their incentive has to be set right. Wouldn't that be even more useful than, say, just bright line rules?
Yeah. So what I do say in the book, and that also builds on earlier work of mine, is that law is incomplete. It's inherently incomplete. Yes. And we also want to have law to be incomplete because we couldn't actually govern a complex, evolving economy if law wasn't incomplete. And that, of course, also that means you want to give different parties the ability to adapt the law to different circumstances. And we do this largely through lawyers, but also through courts and sometimes through regulators. Whom you give this authority, of course, matters a lot. And that's how we institutionalize the law. And I think here we have choices. We could say, certain things we will not give away, or we want to make sure that a regulator screens certain things ex ante. So if we don't know what's going to happen ex post and the danger for society might be really large, we might want to do more screening ex ante if we can do this. I happen to think that this is not a good idea for financial assets because we don't know how they will behave at a systemic level, but nonetheless, we could do a little bit more on that. What I meant by the bright line rules was not to impose bright line rules on all kinds of behavior, but I want to have a bright line rules that we do not give more privileges, more legal privileges to the coders of capital. So that's why I don't want to have more exemptions, more safe harbors. In that sense, sort of a self-constraining bright line rules for the legislature, not to shuffle more privileges in the other direction. But to the contrary, to think about how to rein in the scope of what they can do and maybe to have, where appropriate, more regulation. But it's basically a reconstitution of the collective means of coercion, which is the state and it's our legal system, to make sure that we balance the interests of private parties and autonomy better with the collective interest of financial stability, sustainability, whatever our goals are. And they might vary by country, right? We live in different countries and have different objectives, and I think that's fair. We shouldn't all have to subject ourselves to the same regime.
Okay, great. So I'll probably ask a final question, which is a little bit more theoretical than the previous ones. So everybody bear with me. So I think theoretically, the Code of Capital argues that private wealth critically relies on the law that's ultimately backed by the state, right? So, but we all know that in legal and social theory, there has long been the tradition talking about how people may, arrange order without law, right? So meaning transactions, even including commercial transactions, may be conducted and facilitated by private ordering among transactional parties who might want to opt out of the law, right, legal system, using social norms, industrial norms, and so forth. That those might not necessarily be backed by the state, right? So I'm just wondering, it's curious, what's your current view on that thesis? It's relatively old one, and especially, I guess, at a higher level. So the question is about how do you understand the relationship between law and other social institutions when it comes to minting capital and generating wealth and inequalities?
Yeah, so I teach law and development, and I've been thinking a lot about the relationship between social norms and law. And I think much of the literature in law and development makes the mistake of thinking that law, again, is mostly an instrument by which the state tries to direct society or control society without realizing the intermingling of private power and state law. So I think, what the Code of Capital tries to say is that the law is much deeper, and much of the things that people would say, this is self-regulation, or this is just outside the law, actually is deeply in the law, or at least implicates the power of the law. So a lot of things are happening in the shadow of the law, which is the term that is used in there, and I think we have to recognize that. But not everything. I realize that too, not everything. So I think in situations where you have mutual monitoring, and that might increase with digital monitoring, where we can verify transactions better, the need to rely on the coercive powers of the state is less. So I'm basically saying the coercive powers of the state come in to make relations scalable, to be able to trade with other parties on the other side of the world whom you've never met. That's what the state or the authority of the law gives you if you can code assets as being legally enforceable. We might substitute this with the digital code. We might have relations. We might have ethnic relations. When you think about the diaspora in Southeast Asia, the Chinese diaspora, and sort of, there are thousands and thousands of people who have traded over centuries without direct backing by the state. You can create these networks, but they have scope limits. And I think the combination of state power and then the ability to extend state power from one jurisdiction to another has allowed us to scale the system much larger, but not endlessly. And I think there might be substitutes. So it's a really great question and goes really to the heart of what I like to think about as well. So thanks for that.
Thank you. I saw actually there are 2 more questions from the audience, but I'm really sorry. I was informed by the organizer that we really have to wrap up now. My bad. I didn't see those questions. I was looking at another window. Okay, so again, thank you very much, Professor Pistor, for such a wonderful talk and the follow-up exchanges. Really, I really learned a lot. I hope everybody else does as well. And thanks to everybody in the audience. For those who have not, again, I strongly recommend that you get a copy of this book. Fascinating. And have a good night. Have a good day, everybody, depending on where you are. So I think we should finish now. Thank you. Thanks, everybody.
Thank you very much. It was a pleasure to be here. Thanks for coming. And thanks for the great comments.
Thank you.
Bye.